Whoa! Right out the gate, we got 2 charges on the table. Theft and street racing. Yeah, not exactly your everyday combo. 1 minute it's sticky fingers at Target. Next it's Fast and Furious. Harris County Drift. Let's see how this unfolds.
You were Alan Villisana. Sir? Mr. Villisana, you were charged with 2 cases. You were charged with theft. You were also charged with racing on a highway. On both of those cases, you were facing up to 6 months in jail and or a $2,000 fine.
Quick legal note. When loss prevention keeps eyes on you and calls the cops mid-act, that's airtight. Surveillance footage plus eyewitness plus matching license plate equals probable cause paradise for prosecutors. Villisana doesn't stand a chance on this one.
We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
The theft or the racing?
Yeah, start on the theft because earlier one, yeah.
On January 1st, 2025, officers were dispatched to a shoplifter call at a Target in Harris County, Texas. The complainant, the loss prevention employee, called the officer regarding a theft in progress at the location and observed a Hispanic male wearing a tan hoodie and black shorts making a selection and removed the security tape from a JBL speaker box and placed other products inside a shopping cart. The complainant proceeded to keep the surveillance on the male and observe the defendant proceed to exit past all points of sale without any intent to pay for the items. The officer reviewed the surveillance and observed the complainant make contact with the defendant at the front entrance.
And just like that, boom, new charge, new chaos. Racing at 120 miles per hour in a 65 zone? That's not racing. That's auditioning for jail. Question for you guys. Should reckless racing like this be treated as a felony when it endangers innocent drivers? Drop your thoughts below.
And attempted to retrieve the stolen items, and the defendant proceeded to leave the Target and enter a black Chevrolet Spark. With the assistance of a license plate reader and TLO, the officer determined the motor vehicle to be driven by the defendant and obtained a Texas driver's license, which the officer believed completely matched the Hispanic male captured on the surveillance footage. The total taken was $499.03.
Okay. On the racing, please.
Yes, Your Honor. On March 15th, 2025, the officers observed a black Toyota Camry and a silver Chrysler sedan traveling at a high rate of speed on the main lanes of the Katy Freeway. Officers attempted to catch up to the motor vehicles traveling 120 miles per hour to keep the motor vehicles in sight, but both motor vehicles were still outgaining speed. The posted speed limit was 65 miles per hour. But both the defendant and the silver Chrysler were racing.
The judge isn't playing around. Listen to the tone, firm, controlled, but you can tell there's zero tolerance left. She's basically saying, mess up again and it's lights out. This is classic bond condition lecture mode. Judges give these when they really want to make an example out of you.
Competition side by side at points with both motor vehicles accelerating at a high rate of speed, attempting to outdistance and outgain each other. While the defendant and the Chrysler were racing, they were making evasive lane changes and failing to signal lane change, cutting off multiple motor vehicles to get around traffic, causing victims with their motor vehicles to take evasive actions to avoid collisions. The defendant's motor vehicle at one point drove on the right shoulder to pass vehicles in the right lane and was in front of the silver Chrysler. A traffic stop was initiated.
So driving on the shoulder to get.
A traffic stop was initiated and the officer made contact with the defendant, who was the driver. The defendant admitted that he was racing with the other vehicle and that this was not his first time racing, but his first time arrested, and that he would have ran from the officers if he had more gas in the motor vehicle.
Mr. Villisana, I'm going to find that there's probable cause to go forward on both of your cases. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will revoke the bond on both of your cases and I'm going to put you in jail. I'm also ordering you now not to drive. You will be signing an affidavit with me today promising me you're not going to drive. Do you understand?
How long?
While this case is open. And if I find that you do, likewise, it's not going to go well for you. Do you understand?
Yeah.
Can you print me out more affidavits, please? You're not to go to any target whatsoever as well. If I find that you pick up a third case,
Now we shift to a whole new defendant. Same courtroom, different crime. This time it's a second DWI. Notice how the stakes jump up? Texas takes repeat, DUI is dead serious. The fines double, the jail time extends, and the judge's patience? Non-existent.
it's really not going to go well for you. Do you understand? I'm going to do everything in my power to protect my city at all costs. And if that means putting you in jail and making your bonds high, I'll do it in a heartbeat. Do you understand? Do you have the ability to hire a lawyer, or would you like to apply for a court-appointed lawyer?
I didn't have a job right now, so I can't.
Okay. Deputy Miranda's going to give you an application. I'll have you fill it out and I'll take a look at it with you. Hey, I'm not done talking to you. I'll have you take a look at I'll have you fill it out. I'll take a look at it. I'm going to have you sign a receipt with Victoria. I'm going to have you come back because I'm going to have you sign an affidavit with me today promising me you're not going to drive. And then you'll get with Felicia for your bond conditions.
I'm gonna be able to come back. I don't have a right.
Figure it out. I'll get you a lawyer and we'll start talking. But I don't want any more problems. Do you understand?
No, I haven't been in problems like 5 years. This is the first time I had a case since five.
Go, please. Second offense. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
On March 13th, 2025, an officer observed a blue Ford F250 driving at a high rate of speed. The officer paced the Ford driving 79 miles per hour in a 60 mile per hour zone. The officer observed the vehicle to fail to maintain a single lane, driving over a solid dash line, and driving between two lanes with other motor vehicles in the area when the vehicle failed to maintain the single lane. A traffic stop was initiated. The officer made contact with the defendant, the driver, and sole occupant of the vehicle. The officer observed the defendant to have slurred speech. The defendant stated he drank one alcoholic drink prior to the traffic stop. The officer observed the defendant to be staggering while walking, using the motor vehicle for support, and the defendant to have the mild odor of alcohol upon his breath. The defendant appeared confused, and the officer had to repeat himself multiple times. SFSTs were conducted. 6 out of 6 clues were observed on the HGN. 2 out of 8 clues observed on the walk and turn. 3 out of 4 clues observed on the one-leg stand. The defendant stated he drank 2 to 3 alcoholic drinks prior to the traffic stop. The defendant was arrested. An inventory search was conducted of the defendant's vehicle, and the officer observed a warm to the touch, white cup in the center console.
Alcohol while driving?
That line, stuck like Chuck, says it all. It's rare to hear a judge use slang mid-hearing, but it's effective. She's sending a message. You're out of second chances. What do you think? Is this kind of blunt talk helpful for defendants or too harsh a courtroom?
3 to 3/4 full while with the smell of an alcoholic beverage. The defendant was read the DIC and refused the breath test. A blood search warrant was signed and executed.
Mr. Alipio, I would hope that you would recognize it's elementary that you're not to have alcohol in the car while you are driving. I'm going to find that there is sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I will put you in jail. I am now also taking away your privilege to drive. You are not allowed to drive. If I find that you do, because I will have you sign an affidavit, a promise with me that you're not going to drive. I don't give a rat's behind what your excuse is. If I find that you drive, likewise, you will go to jail. I do not know what your immigration status is, but if you are not in this country with permission and you go to jail and immigration finds you, they will put an immigration detainer on you and you will be stuck like Chuck in custody until this case is over with, and then you get shipped off to immigration. Do you understand?
Yes.
I am sending notice to DPS that there is now a restriction on you that you are not to drive any vehicle that doesn't have an ignition interlock on it. If you were caught driving a vehicle and it does not have an ignition interlock, every officer in the state will know to arrest you and put you in jail. Do you understand?
¿Usted lo entiende? Yes.
Your Honor, just to clarify, so he can drive so long as he has a guardian ad
No, I'm taking away, he's not allowed to drive at all.
Would you consider reinstating his ability to drive because he owns his own business?
I'm not ready yet. All I know is that he's got alcohol allegedly in the car while he's driving, and it's a second offense. Look at me, Mr. Alipio.
Examíname, señor.
Do not drive. Do you understand?
Yes. Yes, sir.
Because of this restriction, you will now be required to obtain a portable device that you're going to take with you everywhere you go to prove to me that you are not consuming alcohol. I don't know if you have a problem with drugs or alcohol. If you do, now is the time for you to address it. Because if I see it becomes a problem, I'm going to address it for you. And I promise you're not going to like the way that I do it.
No te va a gustar como lo.
Do you understand?
¿Lo entiende?
Yes.
Yes.
Because you have a lawyer, I will waive your appearance. That means that you don't have to waste your time coming to court. But it is your responsibility to stay in touch with Lee. If she tells me that she can't get a hold of you because you're ducking and dodging phone calls, you're playing games, you're not responding to her, likewise, I will issue a warrant for your arrest. I'm going to do everything in my power to protect my street at all costs. And I have no qualms about putting you in custody. If you don't believe me, ask Lee. She knows. For now, I will have you come up here, swear to us that you're not going to drive. After that, you'll get to Victoria where we will have you sign a reset. After that, you'll get with Felicia for your bond conditions. And after that, you'll be free to go. It's not forever, but I want to know that he truly appreciates and not just, oh, I'm sorry.
Yes, Your Honor, his prior DWI was in 2003, so he had not had alcohol in a long time.
How do we know?
¿Cómo sabemos?
How many times has he not been caught that we just don't know?
No.
I don't know, but all I know is he's got alcohol in the car. He has a prior DWI, so he's already on notice of what you can and can't do. I have a problem.
No puede
So
Yes, Your Honor.
just proactivity goes a long way.
Yes, Your Honor.
All right, good luck to you, Michelle.
You don't see here for Mr. Flores, Adrian Flores. He's in the holdover. He's got a terroristic threat on a serious bodily injury charge. Represent me.
Hi, how are you?
Harold, what would you like? What are we doing?
Just today was the day we're going to come back for the mental health evaluation, and they just sent it to me this morning. Haven't had a chance to read all of it. They did say he was confident, but I still don't think something's right with him. I talked to him.
So get a second opinion. You know, if you need money for a second evaluation, I'll give you money.
And I don't know. I mean, it might be he's competent, but just something's not correct, with our thinking and reasoning when I was.
Are you able to communicate with them?
I am. Well, just for instance,
Limited fashion or something, or what?
Sorry?
In a limited fashion?
no, he communicate, just for instance, I was just told, well, I just want to go ahead and work it out because then I'm going to hire an attorney and we're going to get them all dismissed later. I'm like, no,
Yeah, don't
we're
worry.
going to, if we're gonna do this, we gotta do it now. We have to decide if we're going to trial now. and
That's
then-
I want to get out as quick as possible and then
Kind of, but that was a little more than that, though. Just,
to talk to him.
I guess it would be a safe thing. Just explain to him what's going on.
Do you mind bringing out Mr. Flores? Do you need a translator?
No, sir.
Adrian Flores, please.
And I think he understands now, but it just might be a misconception. Maybe jailhouse lawyer talk or not understanding his
I don't know.
cases.
Does he have his pending in the 220, this case?
No other cases pending.